Hi guys, how are you doing today? I hope you guys are doing fine. We're the interns at Penal Associates and we are today discussing offences against public tranquility, that are offences not against a private person or particular property but against the public at large.
Hi guys, my name is Bhunesh and today I will be talking about common intention, that is section 34 of the IPC. So section 34 of the IPC describes common intention as when a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if that act was done by him alone. So it basically means that each of the accused and co-accused will be liable for the same punishment. So if to apply section 34 before the court of law in any case, there are two necessary ingredients that should be fulfilled. First is common intention, which basically means that it is necessary that the intention of each one of the accused be known to the rest of them and shared by them. All the accused should be known about the intentions of the other accused and should know them, and it should be shared between them. So it can be a kind of a premeditated plan. Plan can be at the spur of the moment also. And the second criteria is the participation of accused in the commission of the offence. The accused and the co-accused who are participating in the crime should be present at the scene of the crime while the crime is taking place. If these criteria are fulfilled before the court of law, section 34 can be applied.
As in the case for criminal conspiracy, a conspiracy is an agreement between two or more persons to commit a crime at some time in the future. The ingredients of criminal conspiracy are highlighted in section 120A of the IPC, which defines criminal conspiracy as a situation where two or more people come together to commit an illegal act or an act which might not be illegal but is committed through illegal means.
Hello guys, myself Priyank. I'll be explaining the concept of abatement. Abatement is simply termed as aiding an offence. In the case of Sanju versus State of MP, the Honorable Supreme Court has defined the abatement as a meaning to aid or to encourage or to set another one to commit an offence is known to be abatement. There must be two or more persons involved to constitute abatement, which leads towards the agreement and operation of the act. There is also the concept of mass abatement. Section 117 of the IPC deals with the same. There are three types of abatement which are as follows. Insisting a person to commit an offence. Second one is engaging in a conspiracy to commit it, and third one is intentionally aiding a person to commit an offence.
Unlawful assembly, section 141 to 150, arises from article 19, that is the right to assemble. Right to assemble is a constituted right, which means it has certain reasonable restrictions placed upon it, keeping in mind the sovereignty and integrity of the nation. Thus, unlawful assembly constitutes five or more people which may cause harm or injury to a person, property, or public order. Two types of unlawful assemblies are one which is lawful, two converted to unlawful, and one which is unlawful from its very conception. The ingredients needed for unlawful assembly are: first, that there must be five or more people present; second, that there must be a common object; and third, that the common object must constitute either overall government by criminal force, that is like violent protesting; second is resisting execution of legal process or legality of any kind; third, committing offence under the laws of India or under other local laws; fourth, forceful possession or dispossession of property; and fifth, compelling a person to do an illegal act.
Okay, so now when we start talking about actus reus or mens reus, under criminal conspiracy, since it creates a distinct offence and by itself is a substantive offence, it is both actus reus and mens reus, which is not very common in many of the things found.
Under unlawful assembly, the person joining the assembly must know that the object is same, the intention is same, and the design for committing the unlawful act is same. that is when the liability will arise. If the person doesn't know what they are joining when they have joined the unlawful assembly, then the liability does not arise. As for actus reus, the joining of the assembly is in itself an illegal act and does not require any other conception or violence or any other offense in its furtherance to arise liability out of it.
So now we will be talking about the differences between section 34 and 149 and 120. So section 149 is unlawful assembly and section 120 is criminal conspiracy. So the section 34, if we talk about section 34, can be invoked even when there are two or more persons involved in a crime. But to invoke section 149, you have to make sure that there are more than 5 people present at the crime scene or taking part in the crime scene. So if we talk about the differences between section 34 and 120, the Supreme Court of India in the case of Nur Mohammad Yusuf Momin versus the state of Maharashtra held that if the accused and co-accused are both present at the crime scene and are participating in the offense, then the section 34 will apply. But if the co-accused is not present is not present at the scene but has all the knowledge about the situation and circumstances of the crime, then the accused and co-accused will be tried under section 120B of the IPC.
One difference that I have noticed is the importance evidence has when we talk about criminal conspiracy. Criminal conspiracy is, when we talk about them, we can see that they're created privately or secretly, and the evidence might not be sufficient for the court to formulate a judgment. Section 10 of the Indian Evidence Act enlists the various attributes of the evidence necessary in the cases of criminal conspiracy. Many other attributes are present in various cases, such as the very recent Praveen v. State of Haryana, in which the Supreme Court held that it is not safe to hold a person guilty in absence of any evidence to show a meeting of minds between the conspirators.
So now we will be talking about the punishment and the burden of proof for the common intention. So if we talk about common intention, the burden of proof is on the prosecution, who has to prove that the accused and the other co-accused were acting under the common intention. Now if we talk about the punishment, section 34 is a rule of evidence only per se. So section 34 in itself cannot be an offense, and it has to be read with the other relevant sections which are present in the IPC or in the civil offences too.
As for punishment, it is present in section 120B when we talk about criminal conspiracy, and it can be either punishable by death, imprisonment for life, rigorous imprisonment for a term of 2 years or upwards, and where there is no express punishment provided, there are some kind of some other kind of punishment.
Yeah, so I'll be explaining about the punishment of the offense of abatement. According to section 109 of IPC, one who abets an offense is given the same punishment of the principal operator of the crime if the actus reus of the principal offender has occurred as the result of the inducement made by the abater. In short and concise manner, the punishment of the offender and the abater would be the same.
As for the burden of proof under unlawful assembly, while the cardinal rules of justice are simple and whoever alleges the crime must have the burden of proof, but if unlawful assembly is proved, then the general conception and generalization is that whatever offense follows through, the participants in the unlawful assembly must have agreed to the same and will be liable for the same. While discussing punishment, there are many sections that cover punishment under unlawful assembly, which vary from 6 months of imprisonment to 2 years of imprisonment with or without fine.
So guys, this was an attempt from our side to brief you about to give you a brief introduction about the offences such as criminal conspiracy, abetment, common intention, and unlawful assembly. I hope we guys were successful in imparting that knowledge. Thank you and have a very good day.
Thank you so much.
Thank you.
Thank you.